All right, good afternoon, everybody. We're back. This is New York City InfoGuard, and this is IGTV. We're on with Andrew Tallmer. Andrew is an attorney from Concord's Law School of Kaplan University, and is a constitutional lawyer, as well as a former attorney with the Police Legal Bureau. Andrew, thank you for joining us once again. And, we were kind of talking during the break about some of the things about how this was a search incident to an arrest, and how that's kind of important for everybody to know. Why don't you dig into that a little bit?
I'd like to just highlight for everyone that the two cases that Joe and I mentioned, Diaz and Murphy, the police recovered the devices incident to arrest. The circumstances would likely be different if, for example, you had probable cause to believe that there's evidence of crime on someone's computer, and the computer is at the person's house. Here you would need a search warrant to enter the house, and within the search warrant you would need permission to search the contents of the computer, including the files and whatnot. And that's because that would not be considered a search incident to arrest, but rather a regular search. And so we need to keep that distinction in mind.
Right, and I think it's just so important in Diaz and Murphy because there is no limit, and I hate to say that word, but it sounds like since the sheriff down there was allowed to go into an application on the cell phone and a folder inside of that, what's to say that next time the next case, it is in the Facebook application with a whole customer list and everything else, which gets you into web applications and cloud computing and everything else. So that's kind of interesting. Hey, Andrew, would you do everybody a favor? And I know you've lectured me over this numbers of time, even when I was in the department at NYPD. Would you kind of go over Belton? All right, so people get a context of where we've grown with this, how Belton kind of set up the bright line rule, and then how Gant kind of pulled us all back.
Sure. Another exception to the general rule that you need a search warrant before searching is the search of an automobile incident to arrest. And the Supreme Court in the Belton case, Belton versus New York, decided in 1985, set forth a very easy, very nice, very pro-law enforcement rule concerning searching vehicles when you arrest an occupant. Doesn't have to be the driver, could be anybody in the car. And here was the Belton rule. As long as you've made a lawful arrest, you can search the passenger compartment of an automobile, including open or closed, locked or unlocked containers, as long as the search is done contemporaneous with the arrest. And the search may be made whether or not you think you're going to find anything, whether or not it's a serious or a minor crime for which the defendant was arrested, and whether or not the defendant is sitting in your patrol car while you do the search. Well, that was a nice rule to follow until the Supreme Court decided in 2008 in Arizona versus Gant that that's not exactly what it meant in the Belton case. Gant is not a good case for law enforcement because it restricts the ability of law enforcement officers to search vehicles incident to arrest. The Supreme Court, pulled back from Belton and Gant, and here is the Gant rule. Belton only applies, that is, you can only search a vehicle incident to arrest if evidence of the crime relating to the arrest could be found in the passenger compartment. The court uses the phrase reason to believe. The officer has cause to believe or reason to believe that evidence relating to the crime could be found in the passenger compartment. So in the Gant case, the guy is arrested for driving with a suspended license. He's put in the patrol car. The police contemporaneously search the passenger compartment and they find contraband. The Supreme Court ruled that the search was illegal because the officers could not articulate a reason to believe evidence relating to driving with a suspended license could be found within the passenger compartment. Notice, though, that Belton is still good law if, for example, you arrest somebody for DWI. There you would have reason to believe, would you not, that evidence related to drunk driving could be found in the passenger compartment, so you could do the search. But unless the officer can articulate that reason to believe, then the person just gets locked up and the car has to be left alone, unless you have another way to get into the car, for example, through an inventory policy or the like. So Gant restricts the rule of Belton. An automatic search of a passenger compartment incident to arrest is no longer allowed. One more thing about Gant. The court said police could also search the passenger compartment if the suspect had immediate access to the passenger compartment. In other words, at the time of the search, he wasn't in the patrol car, he was actually arrested while he was sitting in his car, or while he had immediate access to the car. As you can imagine, the court is doubtful that this will often be the case. There's not going to be many situations, Joe, tell me if you agree based upon your many years of experience in the police department, but there are not going to be many cases where somebody in a car is arrested and is allowed to sit in his car or is allowed to stand next to his car while the police do the search. What's probably going to happen is that he's going to be put in the patrol car, and then the police are going to have to make a decision under the new Gant rule whether they can search the vehicle.
Yeah, and that, I think, the time here that you're talking, that the court was talking about in Diaz was one of the issues, and you talk about, the search incident to an arrest and a contemporaneous search. In other words, it happens immediately. Well,
correct.
There was some time in between here, and people were trying to argue whether or not that was a reasonable amount of time. I always try and circle all this back to our friends who are in the modern era today, and not necessarily, all about technology. So Belton sets up the bright line rule. Gant comes in later on and he throws up some exceptions. Police officers develop evidence in danger and escape as some of these exceptions. All right. And now we have Diaz, which kind of threw me for a loop because it's not something that I thought would be upheld by the court. The fact that it is being upheld by the court, I think, really establishes a different way of kind of looking at things. And it's kind of interesting, that we're in this age of evolving technology.
Agreed.
Right. So,
well, go ahead. I'm sorry.
As we go through this, in Gant they mentioned Schimmel and Katz. Could you just give us a little on both of those?
Schimmel, which is the leading incident to arrest search case, said that when the police arrest somebody, they can search not just the person arrested, but the area within his lungible control. In Belton, the court construed the area within a vehicle occupant's lungible control as the passenger compartment. So, by analogy, if they could search, let's say Mr. Schimmel was arrested in his kitchen. If they could search his kitchen, incident to arrest, then the police should be allowed to search the passenger compartment, incident to arrest of an occupant, because that is within their lungible area. The difference in Gant, though, is that at the time the police did the search, the guy is handcuffed and in the patrol car, and therefore the court was unconvinced that he could reach for a weapon or hide contraband inside the car, which means that they no longer felt that there was an officer safety issue involved once Gant is arrested and put in the police vehicle.
Yeah, that's that endangered piece. The
Yes.
officer was no longer in danger. All right, and what does Katz do to this?
Well, Katz is a very old and famous case where the courts talked about the search of the area right next to where the person was standing as being within the lungible area, as opposed to let's say Mr. Schimmel, with an arrest warrant, is arrested in his kitchen. The search cannot be of the entire house. That's what they did in Schimmel. They had an arrest warrant for burglary. They believed he was involved in stealing coins from shops. They arrested him in his kitchen. Then they said, we want to search upstairs. He said no. The police said, bad answer, we're going to search anywhere. They went upstairs and they found stolen coins in his upstairs bedroom. And the court said that this does not follow along with the line of the Katz cases. In other words, there's no way, unless he's arrested on a pogo stick, that the upstairs bedroom is within his lungeable area when he's arrested downstairs in the kitchen. Of course, in the Schimmel case, if the police had a search warrant, there would have been no problem looking upstairs for the coins, right?
Right, because they would have had a warrant for the entire house, and then they just could have inventoried everything.
They could look anywhere where the coins could be.
Right.
If 30 seconds, Joe.
Yeah, go ahead.
I wanted to mention just one more thing about vehicles, and that is that Gant does not affect what's called the automobile exception to the Fourth Amendment. This is also known as the Carroll Doctrine, set forth originally by the Supreme Court in 1925.
Why don't we do this, Andrew? Why don't we bring up the Carroll Doctrine right after these messages from our sponsors?
Will do.
Okay, great.